final matter to be heard this morning is Shaine Ward versus Ohio Department of Job and Family Services. Both sides will have 15 minutes to present oral argument today. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve that time, if you let me know when you get started, I'm keeping the clock this morning to keep you apprised of the passage of time. The court has read the briefs and we are ready to proceed when you are.
I guess I do want to start by saying I do want to request a 5-minute rebuttal before I start. I do want to take this opportunity to mention a few errors that I believe were stated in the brief of Mr. Showalter and errors within the court on page 1 of his brief.
Mr. Ward, I know you're Mr. Shaine Ward, correct? You're the appellant?
Yes.
Okay, thank you.
My name is Shaine Ward, the appellant in this case.
Okay, thank you.
In the introduction on page 1, he stated that benefits, because it was found that he failed to report owning several income-producing properties on his assistant application. It's clear by the abundance of reliable, supportive evidence that Shaine Ward, myself personally, has never owned any income-producing properties, and tax returns show that there was no positive income to report from these income-producing properties that were owned in businesses or LLCs. Anything that was owned by himself individually was non-income producing, was a vacant home in Shaker Heights, for example, that was later transferred into an LLC's business name. There are issues that result into adjudication revolving issues regarding overpayment. I'm stating that there is an overpayment issue on how they calculated the overpayment, how they came about. Really, these are simple issues as in who had parenting rights as the minor child and when those parenting rights occurred. Also, how many members, how they calculated the benefits. Was it for a family member of 1 or 2? I believe that the Ohio Department of Job and Family Services did not calculate.
What do you mean by they didn't calculate it correctly? Just math errors, or failed to include or exclude certain generic types of relevant information?
In regards to the income-producing properties, they took a gross number. They did not calculate the business expenses. They weren't allocating what I received personally from those businesses, which was from a K-1, which was negative. They were taking some gross figure amount. In regards to how they calculated the child support calculations, once I asked to buy my child put on, I don't believe that they either added my child correctly or they determined that they, in fact, determined the child did not live with me. But as you guys know from many court appeals through the domestic relations court, that not only was there divorce decrees, no pro-tuncs, you guys determined in a December 5th, 2012 appeal that no orders, regarding one of the third assignment of errors, that it was not accurate to determine that a pro-tunc note, that there were no orders to be merged or vacated in that. You determined that shared parenting plan was the best interest of the child, and that decree was dated in March of 2012. So I believe I had parental rights of my child at that time, or 2013, and that I had rights to my child at that time, and the child was living with me during that time. And there was, in fact, on page 2 of his brief, he reverts back to the OGGFS's ruling stating that there is records show that the property is owned by Ward and advised the county that Ward continually changed the name of the LLC and changed bank accounts. Again, that's stating that these were in a business name, they were allocated properly in a business name, and also on the next line on page 2, he said provided records including the 2012 IRS miscellaneous income reporting form showing that the Portage County Metropolitan Housing Authority paid this amount of money. On January 31st, 2014, I gave them the personal tax returns that show that $30,474 was allocated properly, how it was incorporated in the Schedule E's, how it was incorporated in the business income, and how it was reported negative on my K-1. So I feel that these were these were incomes paid to a business and had expenses to it, and they were into a LLC's name. Also, in the January 31st hearing, they said that there was evidence, verification from county auditor's website and rental property, IRS tax returns, and video receiving cash payments. I do agree that there was auditor's websites of rental properties shown and IRS tax returns, which I gave them to show that not only my AGI, but on the front page of the tax return, that there was no W-2 income, that K-1 was negative, that both personal income and business income was negative. But the video, they did show videos, but the videos was myself paying contractors for not me receiving cash, it was actually myself paying cash on those. So that, I think, was an error. And there's been some dispute on the evidence, how it's been transcribed from the trial court to here, and I received no videos showing that I received cash payments. And if I did receive cash payments, maybe from rental payments or something, it was all allocated properly on the Schedule E's or on the tax returns. And he said on page 3 that according to January 31st, the county terminated Ward's food and medical assistance for failure to verify income. I don't know what they mean by verify income. Again, if there's no positive income report, how do you verify the positive income? I didn't understand. I provided them, not only myself, the tax returns I provided them, but an affidavit from my accountant, who's a CPA, who prepared the tax returns, and he gave a 5-year summary of my income on there.
Help me out. Your tax forms were disclosed.
Yes.
And you have a video, or there was a video of you paying cash.
Correct.
And not receiving cash.
They showed me on a computer screen videos, and I'd never seen that statement, in his brief.
How were these videos obtained?
YouTube videos, I posted them.
Oh.
I posted them. I mean, I'm not hiding the fact that these are friends of mine, and I was just showing videos of myself paying them, and it all came about when one of them passed away, so it was a remembrance type of deal, and they said, here, you're, in the meeting that I was paying them cash, but in this...
Well, what were you paying them the money for?
Well, it was work done on the properties.
And do you have backup documents, the number of hours and what kind of work was done?
Oh, there's receipts given to me.
Okay, all of that was produced?
At the hearing, no. On the tax returns, they're allocated, produced to my accountant, who then allocated that on the tax returns. But at the hearing, that was not asked for at all. I mean, in the business of managing properties, you're going to receive and pay in cash. I'm not saying that cash is the issue here. I think they're properly allocated on my tax return. They're properly allocated.
You say it's normal to conduct business in cash?
I say that there are times that you receive rental payments in cash, and there's normal that it's under a certain dollar amount. These, I mean, you're talking $250 or something like that paid to somebody to work on a property. So I mean, you're not talking about thousands of dollars in paying.
So you're paying them in cash as a favor?
No, I'm paying them in cash because that was readily and handily available at the time, and they showed receipts. I mean, they marked on the receipts paid in cash. And that cash could have been still, you know, could have been derived from a check, could have been derived from a loan. I mean, it's not that it wasn't done to hide anything or done illegally by any means. On page 5 of my brief, it stated that the reason for disqualification was that the client, Shaine Ward, did not report his earned income from self-employment from his rental properties in which he is the 100% owner on. Nowhere in these rental properties, income producing, I was ever personally owner of any properties. Shaine also listed his son Parker in his home, and he was not. I think it's become clear in the appeals that there has been a dispute or changes in how many parenting plans there have been in the trial court. In fact, recently, the mother of my child still felt that she had full custody of my son.
Mr. Ward, you're now reaching into that 5 minutes of rebuttal. You can reserve that time for after the appellee's argument, or you can continue. It's up to you. You have about 4 minutes.
Okay, I'll continue. So the issues are actual statement of my CPA, what I think is substantial, that is credible, showing my income in the last 5 years, that I'm qualified for the benefits, that I didn't intentionally violate any program, that there's still an overpayment issue, that household member, however, that I have a right to appeal to this court regarding because I'm a household member that didn't receive the benefits, or I felt that I was adversely affected by the decisions on this. There's a shared parenting plan or an order in this court, December 5th, 2012, the appellate court number 26372, that ruled that the March 2nd, 2012 was the shared parenting plan was the best interest of the child. That there was a predetermination review done, and they did approve the Medicaid benefits, and they did approve food assistance benefits, all with the same reported income that was reported for the Medicaid and for the food assistance. That I believe that the evidence shows that there was reliable probative substantial evidence, and that they were in accordance with the law within the evidence to seek that overpayment should be repaid back.
And you just have about 2 minutes, a little over 2 minutes remaining. You can continue or reserve that time for rebuttal.
I'll reserve that time. Thank you.
May it please the court. My name is Alan Showalter, and I represent the Ohio Department of Job and Family Services. Today, Mr. Ward attempts to address the merits of whether the overpayment determination of about $6,800 was correct. But the Court of Common Pleas never decided that issue. Instead, it correctly recognized that first, it lacked jurisdiction over his Medicaid appeal because he won that appeal, and he wasn't adversely affected by ODJFS's decision. And second, recognize that his food assistance-related appeals were waived, are moot, or in the case of the intentional program violation and disqualification penalty, had to be appealed through a different process rather than the state hearing process. Because the Court of Common Pleas reached these correct conclusions on all the issues, its decision should be affirmed. First, regarding the Medicaid appeal, his Medicaid appeal was sustained. ODHJFS found that the County Department of Job and Family Services was required to continue his Medicaid coverage pending a pre-termination review to see if he qualified for any other Medicaid programs or had any other Medicaid eligibility. 119.12 only allows a party that is, quote, adversely affected by an order of an agency to appeal to the Common Pleas Court. He had not been adversely affected by this order because it sustained his Medicaid appeal and sustained his benefits. So 119.12 did not provide the Common Pleas Court jurisdiction to hear that appeal. Regarding the food assistance appeal, Mr. Ward signed 2 documents during the record that waived his ability to challenge both the first finding of an intentional program violation and second, the amount of the overpayment. First document they signed is the waiver of an administrative disqualification hearing form, and that can be found in the record on page 12 of the state hearing record, which I believe is document number 10. This waived his right to challenge the intentional program violation and the subsequent disqualification penalty. Ohio law allows an individual clearly that's accused of committing an intentional program violation in the food assistance program to attend an administrative disqualification hearing or to waive that hearing and accept the penalty. And he signed on January 31st, 2014 to waive that hearing. Additionally, on that waiver form, he admitted to the facts that are presented, which were that he failed to disclose this income, and that he understands disqualification penalty will be imposed. Further, on page 14 of the record, still a part of this waiver form, it admits that the $6,802 is the amount of the overpayment that he is admitting to there. Ward cannot waive his right to administrative hearing and then seek relief from the agency's decision in court. If you have an administrative disqualification hearing, the proper procedure then is after that hearing decision, you can appeal that to Common Pleas Court. But there was no decision here that could be appealed to Common Pleas Court because he waived the hearing at the administrative tribunal. And courts are prohibited from providing relief when a party has failed to exhaust its administrative remedies. The second food assistance issue that was before you on the briefs, and the one raised here, is that Mr. Ward waived his right to challenge the overpayment by signing a repayment agreement and repaying the amount in full. The repayment agreement is on page 18 of the state hearing record, which again is document number 10. This was also signed on January 31st, 2014, and allowed Mr. Ward 3 options. The 2 relevant ones of repayment are paying back all the money now or repaying some and repaying the rest in monthly installments. He was informed in this form of the amount of his overpayment because he had intentionally misrepresented his situation or intentionally violated program rules, and told that if he did not agree with the amount ODGFS said he owed, he could request a fair hearing. Instead, he paid the amount on that day, and he signed a cognitive installment note on that day, which also said, by signing this note, you give up your right to notice in a court trial. If you do not pay on time, court judgment may be taken against you without your prior knowledge. The powers of court can be used to collect from you.
Excuse me, I thought you said he paid in full, so why did he sign a cognitive note?
I'm not entirely sure why maybe he chose to pay after signing the note, but the way that the payment in full was made was that he wrote a check from PJ Superior's Properties LLC, which is, I assume, one of the property management LLCs that he owns, for half of the amount, and the other half was removed from an Ohio benefits card of money, food assistance money that he had not yet spent. So the note obviously never needed to be filed. Mr. Ward admitted that this amount was due. He waived his right to challenge the overpayment by paying the amount, and cannot now challenge the amount in this administrative appeal. In addition to waiver, the administrative appeal decision of ODGFS and the Common Pleas Court recognized that challenge was moot because there was no overpayment left to challenge at that point. Mr. Ward had admitted to the food assistance overpayment and repaid the entire amount, and there was no longer an overpayment by ODGFS's terms when the state hearing was requested. The duty of the Court of Appeals is to decide actual controversies between the parties. This court should not issue an advisory opinion on a moot question. There's no case law that directly finds this moot, but analogous case law finding that a satisfaction of judgment renders an appeal moot after judgment is issued, and that the taxpayer's payment of taxes in full rendered moot a matter before a county board of revision addresses the same point, that if you voluntarily pay an amount and agree that you owe it, you cannot then use the administrative tribunal to challenge that overpayment that no longer exists. To address one point raised by Mr. Ward, or 2 points raised by Mr. Ward in his argument today. First, the videos that he mentioned were not made a part of the administrative record because the state hearing decision didn't determine whether that overpayment amount was correct. Instead, the videos were referenced on the administrative disqualification form as part of the evidence that the county had against him that he had failed to report his income correctly. So they're referenced on the administrative disqualification form, but they were never presented at the hearing because the state hearing decision never got to the issue of whether the overpayment amount was correct because it was already moot. The only other issue is that food assistance, very basically, food assistance eligibility has both a gross income and a net income proportion, and gross income from self-employment is a part of that income calculation and needs to be disclosed to the agency. And if that is not disclosed to the county, that is a failure to properly verify your income, as the case was here. If the court has no questions, the department asks that you affirm the decision of the common pleas court.
Thank you. Mr. Ward, you have 2 minutes and 18 seconds remaining.
I would like to talk about the note that he remarks on. The payment was full the same day that this hearing was, on January 31st, and he did state that the note was never filed, or was not needed to file. Regarding the reporting of the gross reported income, gross reported income was always reported when provided the tax returns. It's always, the full, complete tax returns were given on January 31st, and anytime the tax returns were asked for, were always provided. In fact, the CPA even went into details of how much unemployment income I've received in the past, how much W-2 income or personal income was received in the past, and that full disclosure was also given at the predetermination review, which therefore they did approve Medicaid benefits based on the lack of income.
So the record includes statements from the CPA and some sort of transcript form?
He presented them and also did an affidavit where he signed, notarized the document where he did a 5-year summary for 2009, 2010, 2011, 2012, 2013 did it in detail.
Is this just a written report, or was there a deposition taken where he testified to these facts?
He wrote it and provided it, and also was my authorized representative at the predetermination review. He was in attendance at that hearing.
Did he testify at that
And
hearing?
he testified, he spoke.
And there's a transcript of what he said?
Yes. And, that even states there in my second exhibit, where they stated who was at the hearing. The appellant was participating in the hearing along with the appellant's authorized representative, Jay Wright, since the agency was represented in the hearing by Christy Bowman. He prepared and did my taxes for those years, and also said it throughout the first 4 months of 2014, Mr. Ward continues to be unemployed with his sole source of possible income being generated by the S Corporation, which is likely to continue to be a loss, which is negative.
And regretfully, I need to inform you that you have reached the end of your allotted time for today. Thank you.
Thank you.
Thank you both for your presentations. This morning, the court will take the matter under advisement, issue a written decision which will be mailed to both sides, as well as posted on the Ohio Supreme Court website. We are adjourned until next Tuesday.